I'll let you sit in.
No, I'm basically.
Well, if we're going to,
You have a preference?
Myself by Judge Cardone?
I'm not going to feel comfortable regardless. So. Is that your water?
Yeah, that's the one I was drinking.
Down. That's not fair.
Welcome, everyone. Can you hear me there in the back? Okay, appreciate the attendance. We're here to discuss, I sound like I'm a little loud here, the implications of the Sixth Amendment and the right to counsel for the indigent under our federal system. And we have a distinguished panel here, and I say distinguished not by virtue of what they do outside of their participation in this critical study. But I say that based on their commitment and dedication to what they've done during the course of the last year and a half leading up to the accumulation of a report that's going to be submitted to ultimately the Chief Judge of the U.S. Supreme Court, Justice Roberts. And that report, after careful study and testimony, is going to decide ultimately with recommendations the best systemic structure for the right to counsel. That is, should it remain in part within the judiciary or should it be a separate body? And that is the gist of what the Cardone Committee, named after Judge Cardone, is going to review. Now, I want to give you all an understanding of what the scope is of the CJA, which is the Criminal Justice Act study. And in a more generic sense, before I introduce the panel, just to give you a little oversight, what we're talking about is the Sixth Amendment right for indigent representation in the federal court system, all right? And so it's a very fundamental, sacred right, and we have a complexity of issues with respect to parity and equal justice. And one way of looking at this is essentially appreciating the fact that when you see in all of our buildings equal justice under the law and the like, how do we translate it? How do we translate that into the realities of what justice, or how justice is administered on a daily basis in our judicial proceedings, in our courthouses, and the like? And so, before I go any further, let me just go over the scope of what this very significant study is called for. In essence, it's called for compensation issues, employment and diversity efforts within the federal defender offices throughout the country, adequacy of compensation, voucher review, billing, the quality of representation, the availability of qualified counsel, timeliness of appointment, and as I referenced moments ago, the ultimate structure of this Defender and Criminal Justice Act representation as to whether it should remain or with variations within the judiciary or as an independent body outside of the judiciary. So we welcome all of you here. We're happy to be here because this is a very significant evaluation, and I applaud the committee for all their efforts. And before I go any further, let me just give you an introduction of our panel. The chair of the committee, now referred to as the Cardone Committee, we're honored to have with us Chief Judge Katherian Cardone from El Paso, Texas. And Judge Cardone, welcome to Philadelphia. Judge Cardone has served as a judge for many years, has over 16 years of judicial experience. And because of her experience and judgment, the Chief Justice Roberts thought it was, and it was a very good decision, wise to appoint her to oversee this very critical review. Next to her, to Judge Cardone, we have Dr. Robert Rucker. Dr. Rucker is in the Circuit Executive's Office in the Ninth Circuit, where he participates through the Judicial Council and the Defender administered programs, the oversight, administration, and helps in the performance of the critical defense function within the Ninth Circuit. And lastly but not least at all, we have my fellow colleague Kathleen Roe, who's also on the committee, the Cardone Committee, conducting this evaluation. Kathleen holds a
Catherine.
holds a master's in
Known each other for
LLM.
20 years.
Sorry, LLM from Georgetown in trial advocacy. She was formerly a state court judge as well, and as indicated, she's been an assistant federal defender as well as a defender for what I'll characterize, she may object to that too, as the majority of her career. So the committee is well served. And what we're going to do is just really give a fundamental overview. And I am Lee Skipper. I am the federal defender or the federal community defender in the Eastern District of Pennsylvania, that being Philadelphia and our surrounding 8 counties. So our district, the Eastern District of Pennsylvania, is comprised of 9 counties. We have 3 federal districts in the Commonwealth. We have the Middle District, which is represented by Jim Wade, who's here. That includes branch offices and courthouses in Scranton, Williamsport, and the main office is in Harrisburg. And then, of course, we have our Western District, which is Pittsburgh, and an office in Erie. And that office is represented, the federal office there. Lisa Freeland is the defender in that office. So I just want to really give an overview on the, and ask anyone on the panel for an introduction to the audience of just how the right to counsel developed on the federal level from a funding standpoint historically.
How did I get this done? Well, and I'll answer the question, but I do want to say, in the audience, if those of you who are here that are part of the committee, because there's actually 11 members of this committee, they're judges, they're attorneys, federal defenders, as well as CJA attorneys, there's clerks of court, and so I would ask you just to all raise your hands, just so you know that there's a lot of people that are working on this committee. It's not just the 3 of us. All of us were appointed by the chief judge, and we have a report to write to him. So I want to say that the reason we're all here is because of this determination that we needed to, again, study the CJA Act. The last study was done in 1993. And we would not have the CJA Act were it not in the 60s. And last year we celebrated the 50th year of Gideon versus Wainwright. And I think it was because of those 50 years gone by and the attention that was brought to that this last year the Chief Justice decided that it was time to study it again. Actually, there should have been studies done every 7 years. But if it weren't for Gideon versus Wainwright, the whole issue of funding of defense counsel may never have happened. And it was after that our Congress decided that the CJA Act, and it was a hotly contested issue about how to do it. And at the time that it was actually passed, I think it was seen as a very small portion of defendants that were in need of appointed counsel and a way to determine how they would get counsel, in the good old days, and I'm a little bit younger than that, but in the good old days, if you were in court and you needed an attorney and you couldn't afford an attorney and the judge was a little bit concerned about your representation, point to somebody in the back of the room and say, Mr. Smith, you look like you'd like to help out the court. Would you come up and represent this defendant? And that's the way it was done, and that obviously wasn't the best way. So the funding started. Initially, it was primarily, it was CJA attorney, well, I guess they weren't called CJA attorneys at that time, but it was funded so that private attorneys could represent defendants. Over the years, and Ms. Clark might be able to help me, I don't know exactly what year it was decided that we needed to actually form FPDs, federal public defenders and CDOs and their offices to begin to have a more structured system. And so now the vast majority of the defendants in the system are represented by either federal public defenders or community defenders offices. But that has developed, and it's been an ongoing system that has evolved from picking somebody in the back of the room and them doing it pro bono to private attorneys doing it through the CJ Act to actually an entire system, which is the system we're studying today.
You covered everything, Judge
Okay.
Cardone.
I tried.
I
the
mean,
best.
so the audience is clear. You'll hear a series of acronyms now. So the CJA is the Criminal Justice Act, okay? And then you have FPDs, Federal Public Defenders, and then Federal Defender Organizations, of which statutorily there's two types. One is the Federal Defenders, and that office is one in which the court, the circuit, appoints the federal defender, typically for a 4-year term. And then each circuit has a different protocol for review and either renewal, but it's a 4-year appointment. And then you've heard mentioned by Judge Cardone of CDOs. Those are community defender organizations, which has, like my office, a separate board. I report to a board and a board chair, and that community defender organization receives funding federally for the representation through a grant from the Administrative Office of the United States Courts. So we have within the judiciary, within the Administrative Office of the United States Courts, a funding source, and the idea historically was for those who were in need of representation that you would have a mechanism to ensure quality representation, so that, as Judge Cardone referenced, you don't have a situation where a judge is just yelling to the back of the room, who is going to take on the representation of this individual with no training experience maybe, or just out of pro bono or a sense of obligation because they were asked to do so by the court. So I was just wanting to ask, yes, go
Can I
ahead.
just add on that?
Sure.
And, obviously, one of the problems is that you have no idea what the experience level of the folks that the judge just picks out in the back of the room to represent the person. But the other problem was that when they did a study, the Harvard Law School did a study back in the early 60s, they found that under that system, the attorneys who were appointed to represent folks spent no more than, the average would be, 3 hours on their case. And these were obviously significant federal felony cases where they could go to prison for a very long time if they were found guilty. So essentially it was almost that they weren't receiving a defense. So that's when the movement came in 1964, as Judge Cardone said. The Criminal Justice Act was passed. But as part of that whole discussion, some of the folks in Congress wanted to have a federal defender program, an institutional public defender for the federal system. And they just couldn't get that passed. They just couldn't agree on it. They could agree enough that there was a problem and it needed some fixing, but they couldn't agree that they were going to go that far, that they were actually going to have an institution of folks who would do this work full-time, permanently. So it took 6 years, actually, Judge Cardone, it was 1970, when they finally were able to pass the part of the act that said, the revision or the amendments, if you will, that said, all right, now we're convinced we really do need an institutional defender, and that's when the federal defender and community defender programs were born.
And just to go back again, historically, 2 significant cases. You heard mention of Gideon versus Wainwright. Perhaps just a little factual overview would be helpful, but the gist of it is it was a burglary, attempted burglary, a misdemeanor then under Florida law, and the request for counsel by the defendant was denied by Gideon, was denied, and he appealed it after being sentenced and imprisoned. He appealed it to the Supreme Court and ultimately prevailed, and then was retried with the benefit of the assistance of counsel and was acquitted. That obviously is a clear example. And then even before that, in the 1930s, the Scottsboro rape cases, I don't know if people are familiar with that, but really, African-American young boys were picked up and charged, and within a matter of weeks, they were tried and convicted. Counsel there was totally inefficient. Some of them didn't even have counsel. It was just, as Judge Cardone indicated, kind of like who may want to help the court or whatever. But again, highlighting the critical need for counsel, and they're in a death case, and no counsel was provided. So, Dr. Rucker, I wanted to ask you if you could give insights just on, statistically, if you have any knowledge on the increase in federal prosecutions, and how many of those percentages do you think are represented through appointed counsel under the Criminal Justice Act?
I can make a few comments on that. I mean, we started out really with just a handful of cases in the very beginning. And as of last year, there was over 200,000. We estimate about 225,000 representations nationwide. So the increase in this period of time has been phenomenal. And as far as the percentage of representations, of those people who've been accused of a federal crime, about over 90%, between 90 and 95%, of the people are represented either by a federal public defender, a community defender, or a panel attorney.
Now that's an astonishing statistic. Okay, we're talking about approximately 90% of the people charged in the federal system require the services of court-appointed counsel. And it's critical to understand that, because when you look at the resources and the monies necessary to mount a defense, an adequate, sufficient defense, is astronomical. So you can understand the significance of the study. This study is evaluating approximately, because those are the ballpark figures we're talking about, 90% of people who enter who are charged in some capacity in our federal court system. Judge Cardone, can you give an overview of the extent of the hearings for these very questions you've conducted in the various cities in which the proceedings have taken place?
Well, our charge is to write a report, to look at the entire system nationally. It's 50 states. It's a huge country. And so, and the representatives on the committee, all of our committee members are from different areas, but we certainly don't have our finger on the pulse of every district. I believe there's 94 districts, and every district has its own way of determining appointment of counsel and the funding of these attorneys, whether an FPD, a federal public defender, is appointed, or whether a private attorney, a CJA panel attorney, is appointed. These are 94 systems within the national system. And the idea, as you heard Mr. Skipper explain, was that we are supposed to look at the national system and give an evaluation of it with those 14 issues in mind. So the only way we could do that is to travel the country and start holding public hearings. So we're actually holding 7 public hearings. The first one was in Santa Fe, New Mexico. The second one was in, you guys may have to help me here, Miami, Florida. The third was in Portland, Oregon. The fourth was Birmingham, Alabama. The fifth was San Francisco. The sixth one is here in Philadelphia. And the last one will be in Minneapolis, Minnesota. And for every one of those hearings, we divided the country into its various states, and we invited people from every single state in the union, judges, defense attorneys, private defense attorneys, public defenders, people from professors who study these issues, people from, we actually had some defendants come and talk to us about their representation. We have a website that's cjastudy.fd.org, and we're happy to give you that 100 times so that you have that. But you can get on that site. And for every public hearing that we've had, it's been broadcast live. We're currently broadcasting from the federal courthouse here as we do the hearing. Today we had hearings, tomorrow we will have hearings, and Wednesday we will be having hearings. But we are trying to get input from the stakeholders to try to understand what their issues are, where their problems are, so that then when we prepare our paper, we actually can give information about, not only about what we decide are the issues, but we can actually document those issues with case studies and people that have testified. We're also conducting surveys throughout the country, primarily of our CJA panel attorneys. We've had input from all kinds of people. We have studies that have been done. So we're really trying to gather as much information as we can.
And Catherine, can you give an overview or just some examples of some of the challenges you face under the current system as the federal defender in the District of Minnesota with respect to budgeting and resources that you have to employ?
Sure. Well, my office is a little bit unusual because we manage the Criminal Justice Act panel in addition to it being the Federal Public Defender's Office, so I have staff attorneys. We also manage the Criminal Justice Act panel, so we have not only our issues, but their issues too. And their issues are the ones that seem to have at least seem to be rising to the top for the most part as we go around the country. They're very similar issues, And their issues are issues of getting paid for the services that they actually do, and making sure that they get fully paid, and also that they get experts to work on their cases when they need experts, which is very important in defending any case, that if you need an expert witness, if you need an investigator, if you need someone who's a psychologist or a psychiatrist, if you need a forensic computer person, that you have those. Obviously, the government has amazing resources, the federal government, and so we at least need to try to have some resources available if you're going to defend someone adequately or hopefully effectively. We also have staffing issues. Just in the last couple of years, we've had what's called a work measurement study, which actually found that the defender's offices nationally were understaffed. But because of sequestration, we had lost 400 people during the previous 2 years to the sequestration. So a lot of offices are trying to rebuild, and that's something that everyone is dealing with, and then kind of formulating this new work measurement formula and what does it do to the way that you have your office structured. A lot of us are considering restructuring our offices and not having so much emphasis on either on attorneys or on paralegals or whatever it happens to be, paring down in ways that we're just looking at how we organize ourselves differently because of the funding model.
And Dr. Rucker, in your capacity, having participated in the CJA oversight or structured committee within the Ninth Circuit, what are some of the challenges you saw as it relates to funding?
I think it's some of the same ones that Ms. Roe talked about. We've had a number of different issues. The Ninth Circuit is a large circuit.
Yes, so people are quite aware of that, right? I mean, there's often been talk over the years of splitting it up, but the Ninth Circuit consists of, I don't know how many different states, including Guam, Hawaii, Montana, of course, California, Arizona, Idaho.
9 states.
9 states.
15
okay.
districts.
So geographically,
they go all the way out into the Pacific Islands.
Right.
So we have the Northern Mariana Islands and Guam as well. So we cover a large area. We have the largest population as far as circuits, so just that's a base to generate numbers and cases from. We have the most cases both in our district courts and in the Court of Appeals. It's the largest in the country. So there's always been an issue of finding adequate number of counsel and paying those counsel. There's a whole lot of issues I could go into here, but over the years, we've seen the hourly rates increase for panel attorneys, but one of the things we've heard, and we heard it repeatedly today and everywhere we've been, is the hourly rate is not adequate. The hourly rate has increased over the years, but right now, the hourly rate for non-capital cases is $129 an hour. That's the highest it's been. It's not as high as Congress has authorized, but we've heard significant complaints over the last year about people not being able to work for that, particularly when you're looking at the larger metropolitan areas. And I could talk about the Ninth Circuit in particular if you want, because we have like Los Angeles, which is a major metropolitan area, of course San Francisco in the Bay Area, Seattle, Portland, and there's a lot of other large cities, Las Vegas.
The cost of living is astronomical.
It can be extremely high, and particularly in the larger metropolitan areas in California. And a lot of people say they just cannot work these cases for that hourly rate because that has to include their overhead, their staff, and all of that in that hourly rate. So it's very difficult in some ways unless the panel is dedicated, and the panel a lot of times is very dedicated, but they don't have much of a margin of error there at that hourly rate to pay for their overhead, their staff, and to make some money to take home and to live on.
I was going to say, and for some people that may seem like $129 an hour. That's a lot of money. But when you think about it, and as Dr. Rucker said, they have to factor in their overhead. The overhead average is somewhere around $80-some per hour, and in the cities, obviously, even
Much
more. And so even in smaller areas where they don't have the high cost of living, that's still only clearing maybe $49 an hour for an attorney. But in a place where the cost of living is very high, I mean, you go down to maybe $25 an hour for a licensed attorney practicing in federal court, and that's really, it's laughable.
And I wanted to add, Lee, that I think one thing, I mean, we're talking about the right to counsel here, and I think that one thing that we have to emphasize is that these attorneys are fighting defendants that are facing all of the power of the United States government. When somebody is indicted, we are not talking about, a burglary. we're talking about these huge, I mean, you read about them every day in the paper, these huge drug cases, huge, whether it is terrorism cases or whether it is fraud cases, Wall Street cases. These are cases that take a tremendous amount of resources. The government has all kinds of surveillance, all kinds of wiretaps, all kinds of gigabytes of information that are given to attorneys in private practice who have to now go through all of this. And they don't have the FBI and DEA and all of the A's to try to assist them. They essentially are attorneys in private practice who have an office to run, and they have to figure out how they're going to defend these people that are facing huge charges.
And you might have heard the discussion on a national level about the extent of the costs, the massive incarceration, the monies associated with that. For a medium-level federal institution, you're close to $28,000 to $30,000 per year for incarceration. So then, of course, where's the diminishing returns in accomplishing the sentencing objectives, the mitigation, the rehabilitation, and the punishment? Where do you find, an appropriate sentence? But of course, beyond that is the mandatory minimums. Many of you may have heard about the influx of mandatory minimums, where judicial officers have no discretion upon the finding of guilt with respect to those mandatory minimums. And the evolution and growth of this so-called prison population has led to even more of a recognition of the need for various types of reform. Whatever side of the political aisle one may find themselves, it's either cost-effective nor does it accomplish a lot of the sentencing objectives. So you have, an additional conversation going on about the need for various reforms. That's been the discussion of in both the House and the Senate, considerable discussion. So I open up to the panel. Sure, go ahead, Doc.
If I could, I'd like to follow up on one other thing. We were talking basically the last few minutes about sort of general, if you will, criminal cases in the federal court. One of the things that we haven't talked about, and I'd like to raise just for a minute if I may, are the capital cases, the death penalty cases, which are sort of unique animals, if you will. We have the federal prosecutions, which can be very big cases, very costly cases. And the law, when you're talking about death penalty law, is a specialized kind of law, both on what we call the direct death or the prosecution of these people accused of committing murder, and on the back end of that of the capital habeas corpus cases. And you have to have learned counsel to work these cases. That takes a special kind of knowledge that not every attorney has, and that people specialize in this. And it takes a great deal of time and a significant amount of resources to work these cases in the trial phase of these cases and on the capital habeas side, if you will, on the appeal side of these cases. And it takes a tremendous amount of emotional investment on the part of the attorneys as well to do this work. And you were asking me about getting attorneys and resources. On the capital cases, we've seen this in the Ninth Circuit. I've been working on this for 20 years now, on these kinds of cases, that we've consistently had problems getting enough qualified attorneys to do these kind of cases. And this has been a problem not only in the Ninth Circuit, but nationwide. We've had to pull learned counsel from around the country to help work these cases. They're very resource intensive, but they're very emotionally intensive for the counsel as well. And it's very difficult for the people who work these cases, because if they're not successful in what they're doing, their clients are going to be executed.
And I certainly concur. We have a capital habeas unit that's we're very proud of its work and dedication, but the emotional toll and the dedication necessary as you go through the exhaustive process with the obvious repercussions if you're not successful really take a toll. I open up to any one of you the question of what you've heard with respect to some of the tensions that may exist in the current structure. So as Judge Cardone outlined the series of hearings that have been conducted throughout the country, each location has had a particular focus, and the focus here in Philadelphia is one of structure. And so when we talk about structure, what exactly are we talking about during your review?
Well, let me say, and it's something that I've been involved in this for a few years now, but I think the best example is the three-legged stool example. The issue here, and you heard Lee mention structure, is that when you're in the justice system. You have the judge, and then you have the prosecution, U.S. attorney, and you have the defense. And that really is what keeps that stool steady, right? Well, under the CJA Act and the way it's structured now, you have the prosecution, the United States government, who is part of the executive branch. And the structure of the Criminal Justice Act is that the public defense system is overseen by or in the same offices as the judiciary, all right, for various reasons that we've been hearing about throughout the country. Some has to do with making sure that the defendants have good counsel and making sure that the system works well. Some has to do with ensuring that the attorneys get paid. As I said, in the past it would be, hey, you know, would you represent the defendant? And it certainly is an interest of the court to make sure that good counsel is there to represent defendants in criminal cases. But some people feel that it is not the appropriate place, that the defense counsel should be as independent as the prosecution. The problem is, how would that work? Because there is no executive branch for defense counsel. And there is no, and I know when the CJA Act was enacted, this was a huge debate. Where do we put them? We're going to fund this organization. Where do we put it? And in the end, I think the compromise, it's like, you know, I guess they didn't show up at the meeting. We're going to give it to the judges. And so the judges have been overseeing this program for a number of years. But one of the things we're looking at is that really the best place for it?
And the interesting thing is that when they did decide that that's where they were going to put it, it's very clear from the legislative history that the thought was that's where we're going to put it for now, that we will revisit this and make a decision as to where we really should put it, where it makes sense, that we don't have, you know, the folks that are supposed to be the advocates in with the folks who are supposed to be the decision makers about the case, the folks who are supposed to be objective. But unfortunately, we never really got back to it.
Well, an example of where this, and this is my characterization, tension lies, and we've heard from, and certainly from various panel members, this issue of what's called voucher cutting. And can you describe, any one of you, Dr. Rucker, as a part of the circuit? Do you see any of that in your circuit? And why don't you please describe what that is and who makes that determination, at least initially, with respect to voucher cutting?
Generally, the person who makes that determination.
What is it first?
Oh, what is it first? Okay. Well, the attorneys do work, and then they will submit what is called a voucher, and there's different forms, and I won't bore you with all the different forms that they submit their work on, but basically it tells how many hours they worked, and it's a request to be paid.
And who do they submit that to?
It varies across the country. Generally, it will go to the district courts, but it could, in some cases, it will go to the federal defender's office. Sometimes it will go to the clerk's office within the district court who have people to do it. But sort of the general model, if you will, would be go to the presiding judge. And he or
so
she
that would be the very judge who's hearing the case that's before them, okay? And let me just back up for 1 minute. The request for those services, we're talking for the submission of the voucher, which typically occurs, if they're not incremental payments, at the end of the proceedings. But the initial request, say, for experts and the like, also has to take place before that judge. Is that right?
It is.
Presiding judge.
There's a small amount. It is a small amount of money, $800 that they can.
And that $800, so the audience is clear, is a statutory cap on the limit on expert services. Is that correct?
That's right. But the attorney can ask for more, and the presiding judge can authorize more. And if it's said to be an extended or complex case, then it would need the approval of a court of appeals judge, the chief judge of the circuit.
And when we say expert services, that $800, what are we typically talking about in terms of what's requested?
Well, it could be any number of things. It would depend on the type of case. But as Ms. Roe mentioned, I mean, it could be a psychologist or psychiatrist to do some kind of examination. It could be a neuropsych. It could be a forensic accountant. It could be a ballistic expert, and the list goes on and on.
Or a street crime investigator.
It could be a street crime investigator, or somebody who specializes in e-discovery with computers and wanting to look at all the many different forms of electronic data that we have.
And would it be fair to say that the committee has issue with that low amount, that threshold
Well,
that
we
maximum
don't have
of-
any issues, but we are presented with issues, and
Okay.
and there's two parts to this. The first part of the issue is nobody is overseeing the prosecution. Nobody is saying to the United States government, you know, you want to hire who from the FBI to investigate this defendant? No, they do their investigation, and that's all part of the case, and they have a lot of resources. But if once the defendant is charged, if they need an expert, whether it's a ballistic expert or, you know, I mean, we have huge cases that they have to go to the judge. And the statute actually says not only do they have to go to the judge to ask to get this expert, but they have to explain why in their case they need the expert, okay? So the same judge that's going to decide the case is making a determination of whether the expert is needed and gets an explanation of why you're asking for the expert. And there's some people who feel that's inappropriate. Then you've got the issue of the amount. 800, you don't have to go to the judge. The statutory is up to 2,400. 2,400. But, you know, I live in El Paso, Texas, and to find experts, child pornography has been a huge issue throughout the country. And I had 14 child pornography cases in 1 year. And to find a child pornography expert in El Paso, Texas is not an easy venture. And to find somebody who's going to come across country to help or to assist in that investigation, you're not going to get them for $2,400. So it's those kinds of issues that defense attorneys are facing.
And do any of you care to discuss the significance or the shift with respect to mandatory sentencing under the guidelines in our post-Booker world, and what type of dedication of resources is necessary post-Booker, which is now some 10 years old?
I mean, a lot of folks think that once a case either goes to trial and let's say the person is found guilty, or it pleads out and the person is found guilty, that basically most of the work is done. But in the federal system, the reality is that you're just gearing up for a whole new kind of part of the case, which could be more time invested in it than the beginning part of the case, depending on the case itself. And that's because it's not just that the guidelines apply and you get to a certain grid and you find the place that meets and the person is looking at, let's say, 37 to 46 months. It's that the entire person is considered by the court, and the person's circumstances are considered by the court. You can look at all the different factors, not just the guidelines themselves, not just the crime that occurred, but the person. And that's the change in what we call Booker, which is a United States Supreme Court that said it's not, the guidelines aren't mandatory. It's not just look at the guidelines and pick a number. It's you actually have to look at the person. And so what's come from that is that attorneys spend many, many hours trying to get to know their client, trying to get to know what information they could provide to the court that would help the court see this person as a whole person and make a good decision about what the appropriate sentence is. And that may require that you seek a psychologist or psychiatrist if they have mental health issues, or if they have challenges that certainly led them to the place that they're at as far as committing the offense. It may be that you get an accountant, because there are certain parts of the case that even though the person was guilty, and that's why they pled guilty or were found guilty, that if you had a forensic accountant, that you could make a determination that the loss was much lower than the government has said it is, and therefore the amount of time that the person is looking at for being incarcerated is much different than that which the government is asking for. So it adds a whole new layer to the case, really, and that's why you need experts. You need some folks hire what they call a mitigation expert, someone who can bring those factors to the court and write a report that might be helpful to the court. All different kinds of areas. We use sentencing videos that also sometimes just what this person's life is like, especially sometimes in immigration cases where the family doesn't want to come into the court to speak to the judge because they may be in the country illegally. And so you do a video, a sentencing video, that kind of presents to the judge what they might be able to present to the court, but for the fact that they're afraid to come into the courthouse because they might be arrested and deported.
Judge Cardone mentioned, one of the high docket cases, so to speak, is the influx of child pornography cases over the years, which, as Catherine was saying, certainly necessitates extensive mitigation and use of experts at the sentencing proceedings, given the gravity of and the issues involved in those type of cases.
Well, can I add, and defense counsel, it's not just about finding somebody guilty or not guilty. And there's a system now in place that so many defendants plead guilty. The government, as we've talked about, has huge resources, and so when they're facing these huge resources and whether they should go to trial, they make a decision to plead guilty. There is, in the system, inherently in the system, are these systems or these functions that make it advantageous to the defendant to plead guilty, because that would assist them in a lower sentence. But so by the time they get to me, it's not like I sat through a trial that lasted 6 weeks and I really understand this defendant and understand, the ins and outs of why he should get, 36 months or 47 months or 210 months. I barely know this defendant because he has worked the entire deal with the U.S. attorney and has come into my court to plead guilty. The only time I see the defendant is at sentencing. So defense counsel has an important role in getting that for me to know that defendant. How would I as a judge sentence somebody if I don't know who I'm sentencing? And so I want to emphasize that, when you represent somebody, obviously guilt and innocence is an important part. But whether you go to jail for 36 months or you go for 210 months is probably an even more, or in some cases, more important.
Exactly. Okay, I now want to turn to some of the questions we've received from you, the audience. And the first has to do with whether such a study is being done, that is a review of indigent counsel representation on our state level. And before I present that to the panel, let me just note that in Pennsylvania, we actually, Dave Radowski, who's actually the chair of my community defender organization, along with the ACLU, is involved in litigation, and they had a hearing, I think a week or two ago, on the very question of the inadequacy of funding in the county of Luzerne as to how the monies are provided or lack thereof for indigent defense, criminal defense representation. But what's interesting about that litigation is that both the ACLU and the Justice Department, the U.S. Justice Department, joined in that suit. And in Pennsylvania, we have a system that's really in the minority as to how funds are paid for state indigent criminal representation, and that is, it's from the county. So there's no statewide system in Pennsylvania, which really separates us, and it's grossly inadequate, grossly disproportionate. It's a by-county distribution, and indeed in some counties in Pennsylvania, the defender is appointed by the county governing board, and not the most politically attractive body to be asking for funding for this vital Sixth Amendment function. So the answer to that question, I can say, is no on behalf of the sitting panel. We do have the benefit in the federal system of more uniformity, despite the different practices you've heard about in each district. We do have that sense of uniformity, and frankly have been beneficiaries of, over the years, much better resources. But nevertheless, when you compare them to what the Department of Justice has, they're certainly lacking. And then the reference to that question also noted the situation with respect to the state of Louisiana, and I assume that question was referencing what's been going on in New Orleans. We know in New Orleans that the revenue necessary for representation of indigent defendants for the Defender program is derived in part from traffic ticket citations. So, and it's gotten to a point where the defender there, the state defender, declined appointments, that the threshold, the number of cases, the demands of the work, the necessary proper investigation just shut down the number of cases that the office would accept because of a lack of resources, a lack of funding. So this is an issue that is even more dire on the local level throughout various states in the country. So I could take care of that question.
Thank you.
What are the federal crimes that are using defender services? I can answer that question too.
All of them.
All of them. So we've seen a substantial increase in the federalization of, in the growth of crimes. You had historically a lot of street crimes, your common robberies, your common gun possessions, that then were adopted into the federal system, and the basis for the jurisdiction is either an interstate nexus or an insurance through a bank robbery, FDIC insured, or the traveling or production in interstate commerce. So there has to be a federal nexus. But having said that, basically every offense you can find is the reality, a federal nexus. Obviously, we know under the 10th Amendment all other powers not specifically stated are reserved to the states. So the federal courts are courts of limited review and jurisdiction, but the origination of these additional offenses really created this influx where I think it's fair to say, as I just stated, there's a basis for federal jurisdiction you can find, pretty much anywhere. And to give you an example, in the Third Circuit, a robbery, a street crime robbery, that jurisdiction is derived from that some of the items or what was attempted to use or what was used in the employ of the commission of the robbery is derived from a product that went through interstate commerce, okay? And the case law in the circuit with respect to that nexus, that weak nexus, is attempted or threatened to impede or affect interstate commerce. So it doesn't even have to travel in interstate commerce, but if it had the impact, however slight, on interstate commerce, then there's a federal jurisdiction basis. So that answer is clear.
Can I also say, Lee, that's one of the reasons why Dr. Rucker had talked about in the beginning when the Criminal Justice Act was first passed. I think that first year in '64 was something like 16,000 appointments. And in 2015, 50 years later, It was 225,000 appointments. So that's roughly 14 times the number of appointments, right? Part of that is really about the federalization of crime. So now we see cases that are just your usual gas station robberies or pharmacy robberies. They can be federal if the U.S. Attorney wants to bring them federal. Your average guy with a gun, they can be federal if they want to bring them federal because, honestly, the reason they do that is because the law is better in most states federally for the government, and also the penalty is so much more substantial. So if the local folks say, this is a guy who's been a problem, or we don't like him, or we think that this search might be suppressed locally, but federally it's not going to be suppressed under federal law, then the case comes over. We see a lot of those where they actually start in state court. Things, the person doesn't take a plea right away, and then the next thing you know, it's in federal court. Well, in federal court, for those same cases, it's triple the penalty. So instead of the 5-year, at least in my district, instead of the 5-year mandatory minimum that he was looking at in state court, he's now looking at a 15-year mandatory minimum and usually a higher sentence than that. That's just the bottom. That's just the floor. So we've seen the government decide for lots of different reasons that they're going to bring more cases federally. And that's why when I started in my district, I think there may have been 20 assistant U.S. attorneys, and now there are somewhere around 50-some. Again, because they needed to increase the number of folks because they were charging so many more federal cases.
And those of you who can recall Senator Specter, and of course he chaired the Senate Judiciary Committee, he was influential in these efforts, specifically as to gun cases, being legislation created to obtain the federal jurisdiction necessary for these offenses. And then what happened was you had, as part of this growth, you had a series of county district attorneys who were what we called cross-designated, and they were called special assistant U.S. attorneys. You'll see that in the federal system. There's a lot of, like, agents. I've yet to meet a agent that's not special. They're all special. And that's one of my questions on cross-examination. What just makes you so special? Can we all be special? Can I be special? But
You're a special defender.
a special defender, exactly. But they're
They
all
say,
special.
Mr. Skipper, you are special.
Yeah. but you know, we can credit, I'm sure, J. Edgar Hoover for that characterization. Everybody was special. But nevertheless, I digressed. The reality of it is we had county special assistant U.S. attorneys who reviewed on the county level cases that they would then recommend to the federal government, to the U.S. Attorney's Office for prosecution of various offenses. So they had an incentive to bring cases federally. The resources were increased by all the agencies, but the corresponding necessary increases didn't always exist for the defense of those cases. So you'll see that, you know, that it doesn't always catch up in terms of parity, in terms of what's necessary. Although we've gotten a lot of support over the years, there's still that imbalance. Here's a question that must have come from an attorney. Please comment on appellate and other resources for CJA counsel. There's a huge difference between being a lawyer in a federal defender office and a solo CJA attorney.
I'm happy to take that.
Okay.
What he's talking about here is that as we talked about, the Criminal Justice Act essentially sees a system that marries both public defenders who work for the United States government in the office of defender offices and private attorneys who are appointed by the court through the Criminal Justice Act. And their funding comes from the United States government, but they're attorneys, you know, you see their offices every day when you walk down the street, they're private attorneys. There's a lot of reasons for that. Right now, a lot of cases are multi-defendant cases in the federal system. So the federal public defender or the public defenders can't represent every defendant in a case because they have conflicts. They can't represent every case because there are so many. I think we said 90% of the cases are now in the system, and there just aren't enough federal defenders to do that. So you have attorneys in a private practice, and then you have the defenders. The defenders are funded through the United States government. There's a pot of money set aside for them, and there's an office that sort of oversees how that works. But they're salaried. And then if they need experts, they have their offices set up with paralegals and investigators and all those things that they may need within their offices. Attorneys in private practice, as I mentioned, don't have that. If they get a case appointed to them, if they're a solo practitioner, they got to figure out how to get experts and to do all of that. If the case goes up on appeal, or if it's a high budget case, they have to actually submit a budget that goes all the way to the Court of Appeals to be approved by the Court of Appeals. So they're in a very different sort of system as to the way they're funded. I hope that answers your question. Yeah, okay.
I do this real briefly. All I'm asking is your committee looking at whether there should be, as some states have, resource offices for the private attorneys?
Well, there are resource offices for the private attorneys, but are you saying, so explain to me, when you say resource offices.
That a CJA lawyer has an appellate unit that he or she can call. In Skipper's office, the person can walk down the hall.
Right.
Say, I need some help. That's a radically different setup. And I'm
Right.
a defender, I was a CJA attorney.
Right.
It's a radically different setup. I'm just wondering, as part of your brief, so
Right.
to speak, is that a question that's been looked at? Because in my view, there's ultimately a disadvantage to having a CJA attorney as opposed to having a federal defender.
Well, okay, so this is some of the differences that we see throughout the country, and anyone who has a little bit more information on the actual way it works, please jump in here. But there are various methods to address. If you're on an appeal, my understanding is there is, through the Defender Services Office, there are people at that office that can assist. There are briefs filed there. to assist on various issues. The federal public defenders actually assist, at least here in my district locally, if an attorney in private practice is having issues, our federal public defender has research and writing staff that will assist the CJA attorney and help develop issues. There are resource counsel on federal habeas cases or death penalty cases. So there are different methods to address those concerns. It really depends on what the issues are and where to point that attorney to get them. So I don't know if, Catherine, you want to add
Well, I would say
anything?
that I think that it is different. Certainly, CJA attorneys don't have the same resources that defenders have, and that's just the nature of being kind of in an organization. You have a budget, you have all different kinds of folks. If someone in my office needs to, talk through an issue that's in a brief, then they go and talk to another lawyer. But I mean, obviously, CJA lawyers can do that. They're just not collaborating usually on the same piece. But I think the reality is that there aren't any resource centers like that, and I don't know that we've actually considered that. But it's something to think about. But I definitely think it's true that if you do an appeal and you're a solo practitioner, there are different challenges that you have.
Yeah, absolutely.
So the last question we have, is there still an opportunity, it's a compound question. Is there still, well, it's not a compound question, it's two separate questions. Is it too late to testify at the hearing in Philadelphia? And then secondly, why isn't a client on the committee?
Okay. It is too late to testify on the Philadelphia hearing only because we are absolutely packed and already have an agenda. However, it's never too late to submit comments. We are accepting public comment at cjstudy.fd.org. We are also having another public hearing in Minneapolis. And so if someone wants to testify publicly, the only concern would be that you'd have to come to Minneapolis. But we do want to hear from you. And so if you have something to say, feel free to contact us. We are happy to take it in writing. We are happy to take it orally. We are happy to accommodate that testimony because it's important that we hear from anyone who feels they have something to contribute to the committee, and we do want to hear it. The second part of your question. Client. There is no client on the committee, but we have interviewed and we have documentation from clients. We've had submissions from clients. We've actually had clients at public hearings so that we could hear from them. But there is none of them on the committee.
Okay. And just lastly, and I'll be happy to entertain any questions myself from the audience, but we have a host of people here who not only serve on the committee, the Cardone committee that we're talking about, but defenders from districts throughout the country. And we have Kate Clark, who oversees the Defender Services Office in Washington, part of the administrative office within the U.S. courts that we've been referencing. And with that, I'd be happy to take one or two more questions before we conclude. Yes?
Is there anything that you can say publicly about ideas that are being considered if, in the event that the jurisdiction of the oversight is moved from the judicial branch, from the administrative office of courts?
Well, we're just gathering information, but there are all kinds of models out there. We've talked about, I'll give you probably the most radical, and that is one person recommended that the Justice Department is about, it's called justice, right? But yet all they do is prosecute people. So maybe there should be some sort of bifurcated system within the Justice Department where you have an Attorney General and you have a Defender General, and they both have the responsibility to prosecute and defend. Now that may sound like an absolutely crazy idea, but that's in the military systems, and we are going to be hearing from them. They do that. JAG officers on occasion will represent the person being court-martialed. On other occasions will have to prosecute them. So we're looking at every kind of system out there. We don't know the answer. Perhaps they're a separate agency. Perhaps they're an agency still within the judiciary, but somehow have more say in the way their office runs. There's all kinds of recommendations out there, and we're just trying to, and that's one of the reasons we're here in Philadelphia. And if you're interested, certainly you can watch the hearings, you can come to the hearings, but that's exactly what we're trying to talk about.
And the key, if we haven't made it clear, is the concept of independence. The key is to make sure that the defense can be independent of the judge and make decisions based on what's best for their client and not what's best for them to keep their relationship with the court or to make sure they get paid. And those are all the tensions that we're dealing with. We want to make sure that that lawyer makes decisions that are best for the client.
Okay, I want to thank the panel and the interest of the audience. I see our time has run out, and I hope you found it to be an informative, insightful understanding of what the review is.
Really. Okay. Can't get unhooked here.
Yeah.